The broadcast of the regular meeting of the Police Conduct Oversight Commission will now begin.
Good evening. My name is Malaysia Abdi, and I'm the Vice Chair of the Police Conduct Oversight Commission. And I'm going to call this meeting for May 11th, 2021 to order. As we begin, I will note for the record that this meeting has remote participation by commissioners and city staff as authorized under Minnesota Statute Section 13D.021 due to the declared local public health emergency. The city will be recording and posting this meeting to the city's website and YouTube channel as a means of increasing public access and transparency. This meeting is public and subject to Minnesota open meeting laws. And I would like to note that Chair Jackson is unable to join us tonight due to a personal matter. At this time, I will ask the clerk to call the roll so we can verify a quorum for this meeting.
Commissioner Sarah.
Present.
Commissioner Crockett.
Present.
Commissioner Jacobson.
Here.
Commissioner McGuire.
Present.
Commissioner Pinot.
Here.
Commissioner Sparks.
Present.
Commissioner Sylvester.
Here.
Vice Chair Jackson. Vice Chair Jackson.
Lisa, I think what's confusing is you're saying Vice Chair Jackson, Chair Jackson is absent.
Oh my apologies. Vice Chair Abdi.
Present.
There are 8 members present.
Okay. Let the record reflect that we do have a quorum. Next, we'll proceed to our agenda, a copy of which has been posted for public access to the City Legislation Information Management System, which is available at lims.minneapolismn.gov. The first motion is to adopt the agenda. May I have a motion to adopt the agenda?
So moved by Commissioner Pino.
May I get a second?
Second by Commissioner Sarah.
Okay. Will the clerk please call the roll?
Commissioner Sarah.
Aye.
Commissioner Crockett.
Aye.
Commissioner Jacobson.
Aye.
Commissioner McGuire.
Aye.
Commissioner Pino.
Aye.
Commissioner Sparks.
Aye.
Commissioner Sylvester.
Aye.
Vice Chair Abdi.
Aye.
There are 8 members. There are 8 ayes.
So the motion carries and the agenda is adopted. The next item is the acceptance of the minutes from the meeting of April 13th, 2021. May I have a motion to accept the minutes?
So moved by Commissioner Sarah.
And may I have a second, please?
Second by Commissioner Pino.
Okay. Will the clerk please call a roll?
Commissioner Sarah.
Aye.
Commissioner Crockett.
Aye.
Commissioner Jacobson.
Aye.
Commissioner McGuire.
Aye.
Commissioner Pino.
Aye.
Commissioner Sparks.
Aye.
Commissioner Sylvester.
Aye.
Vice Chair Abdi.
Aye.
There are 8 ayes.
The motion carries and the minutes for April meeting are accepted. So the next order of business is the acceptance of public comment. So before I open the floor, I would just like to pass it over to city staff to address some public comment questions.
Actually, Vice Chair Abdi, we were going to address those at the time of the case synopses
okay.
Later in the agenda.
Okay, thank you. So I will now open the floor to invite comments from the community. We will limit public comment period to no more than 2 minutes per speaker. With that, are there any community members online who would like to address the commission? And remember to please press *6 to unmute yourself.
Hello, this is Dave Bicking, if I may proceed. I I'd like to commend the Audit Committee and the Policy Committee for their work. They have truly hit the ground running. I hope the full commission will follow up on the excellent presentation on no-knock warrants at the Audit Committee. Communities United Against Police Brutality is starting a new focus on that topic, search and arrest warrants, and the results, the raids that follow those, including the process of applying for warrants and the court approval. We have some additional resources that we will send to the Audit Committee. This has received new attention due to the no-knock raid that I hope you've heard about in Coon Rapids at the wrong address due to really shoddy work by the MPD. I also hope the full commission will act on the recommendations from the Policy Committee on pretext stops. I hope that they will return to the topic also of positional asphyxia after the city attorney's office blocked them from meeting in March. So I think that's a very important thing to take back up. I hope the Audit Committee will return to its work on police response to public protests, which I believe was also blocked for a while. And incidentally, I want to thank the clerk for fixing the links in that Audit Committee agenda, because those are very important resources for the commission and the public. In your work on coaching, which you'll be addressing today, please pay close attention to the letter from the Legal Rights Center, which has also been endorsed by the NAACP, the National Lawyers Guild, Voices for Racial Justice, and CUAPB. There are excellent points in there. I hope that you'll look at that carefully. I'm disappointed at your last meeting, at the suggestion of Commissioner Pino, you sent a letter to the chief. And I'm disappointed that the chief has apparently not responded to your letter, and I don't see anything on the agenda about him appearing at your meeting. Don't feel too bad. He did not respond to a similar request from the city council. Finally, you may have heard that just this morning, Amani Jafar was appointed interim director of the Civil Rights Department. I hope there will be some information at this meeting regarding the transition at the OPCR. Frankly, I hope you will be working with someone less obstructive and more helpful. And I hope that the Civil Rights Department gets a good leader sometime soon. In the meeting this morning, the mayor said that they will soon be starting a search. This is almost 6 months after Velma Corbel left as the Civil Rights Director. Shows how seriously the city is taking the Civil Rights Department and, you know, the pieces of it like your commission. Thank you for your time.
Thank you for your comment. Would anybody else like to address the commission, community members? Please remember to press *6 to unmute yourself.
Madam Vice Chair, Commissioners, my name's Chuck Turchik. I live in Ward 6. Sorry about all the recent emails. You can probably tell the day, if not the hour, that my classes end for the semester just by looking at when my flood of emails starts. Unfortunately, this bureaucratic comment is going to take up my entire time, so the comment I would have made, I submitted through LIMS and Smartsheet forms. Maybe from what I just heard, this comment might be answered later in the meeting. All 9 of you are essentially new to how the case selection process for the 3 case summaries you review each month has taken place in the past. So many monthly meetings in 2020 were not held due to COVID and the lack of a quorum that even Commissioners Sarah and Pino are probably not familiar with that past practice. And Casey Carl is new to this process too. So this isn't your fault at all. Nor am I saying you're new and you have no right to change the process. You have every right to do that and should do it if it will help you get the materials in a more timely manner. But why OPCR staff didn't tell you during last month's meeting that usually the case selection process has taken some discussion because more often than not, there's a tie vote on the 3rd request. And why Joel Fussy from the City Attorney's Office didn't tell you that making your case selections by being polled outside of your meetings is setting yourself up for open meeting law violations is beyond me. Maybe OPCR staff and Mr. Fussy were not in last month's meeting. And you weren't told this during your orientation, but open meeting law violations can subject each of you as individuals to $300 fines for each violation. I am also puzzled as to why tonight you are still going to discuss 3 case summaries that you did not select, just as was the case in April. After hearing my comment at the April meeting and hearing Casey Carl confirm my observation when he said there had been problems in, quote, getting the accurate case summary files to you, unquote, I wish one of you had made a motion then to request for review at this meeting case summaries for the 3 cases you had actually selected in March. There is a silver lining, though. If the OPCR is not going to give you the case summaries for the 3 cases you actually select, then there might not be any open meeting law violation, since the out-of-meeting decision will have been irrelevant. Thank you for your time, and thank you for hearing this comment.
Thank you for your comment. Would anyone else like to address the commission? Okay, well, I would like to thank everyone who spoke for public comment tonight. Since we have a number of special guests for our coaching presentation, I'd like to take the matter up next. As you'll recall, coaching was originally intended to be discussed at our April meeting and was postponed at the meeting to the May meeting. So I'd now like to recognize Jared Jeffries, Mayor Fry's Principal Public Safety Policy Aide, to introduce this presentation.
Thank you, Vice Chair Abdi, and thank you, PCOC commissioners, for inviting me and several of the other city staff to your tonight's meeting to give a presentation on coaching. We hope that this is a great opportunity for everyone in attendance here to kind of just learn more about the topic of coaching and just give a little bit more of an overview and go into some nuance about the topic as well. I would ask the clerk's office if you could go ahead and start projecting the presentation if that's possible. Perfect. Thank you. And we can go ahead and go to the next slide here. During this presentation, we will be hearing from the Human Resources Department, led by the Chief Human Resources Officer, Patience Ferguson, from the Minneapolis Police Department, led by Chief Arredondo and Deputy Chief Amelia Huffman, and from the City Attorney's Office from City Attorney Jim Rauder and Assistant City Attorney Joel Fussy and Trina Chernos. And we can go ahead and go to the next slide, please. And we'll go ahead and start off, and I will hand it off to Patience Ferguson, who will give an overview of the coaching from a human resources perspective and how it's applied at the city.
Hello, everyone, and I want to thank you for this opportunity to talk from the HR perspective regarding coaching in the city of Minneapolis. Before I do that, I think it would be important for me just to give an overview of the city workforce as an enterprise. The city of Minneapolis has over 4,000 employees. We are 92% union, and we have 22 departments. We have an HR team that works to support the city enterprise workforce, and we have 4 different divisions. One is learning development, the other one is total compensation, labor relations, and HR business partners. So with that in mind, I want to say that I'm going to come from the city of Minneapolis enterprise perspective with regard to coaching. The topic of coaching and the way coaching is done is a generally accepted process that is used not only in the for-profit sector, in the nonprofit sector, it is also in the public sector. And it is used as a way to really work and provide just-in-time, one-on-one feedback with a developmental focus with regard to employee performance and employee behaviors. I'd like to just talk a little bit more about that. First of all, it is a one-on-one developmental process. It provides immediate feedback and direction. It is a tool to really help employees get better and improve on their job. And it's an opportunity for both the supervisor and the manager, the manager and the employee to really come and work together to provide and support and to help the department meet its goals and objectives. Typically, how this is used is in a performance management process. And just like many organizations, the city of Minneapolis does have a defined performance management process. We call that Performance Minneapolis, Perform Minneapolis. What that means from a performance management perspective is there are components of performance management. One is around establishing performance standards. The next one is communicating those standards, and then also providing one-on-one guidance and support against those standards. And that's how coaching is used. It is a tool that is developmental in focus. It is a tool that may require some redirection depending upon the nature of the behavior or the performance. And it's also a way to provide guidance, support in helping that employee grow, develop, and achieve their own personal developmental goals in that particular work unit and in that particular organization. If you could go to the next slide, I'd like to share a little bit more about that. So here is an example of non-disciplinary corrective actions. Coaching could be suggesting more appropriate behavior for handling an incident and discussing future expectations for that employee. Another way that non-disciplinary corrective actions through coaching can be used is providing some direct counseling to the employee, listening to what the employee has to say, helping and working with that employee to see what some other options could be. In some instances, it may require additional training. It may provide opportunities to do a little bit of skill development so that that individual really has the tools and the resources they need to become successful. And last but certainly not least, there may be some other non-disciplinary actions which will really help to support and correct and redirect the employee's behavior.
Perfect. Thank you so much, Patience. We all really appreciate your input from the HR side. And now if we want to go ahead and move to the next slide, we'll go ahead and hand it off to Chief Arredondo and Deputy Chief Huffman to kind of give an overview of how coaching is applied specifically within the MPD.
Good evening, Vice Chair Abdi and Commissioners. Thank you for having me this evening along with Deputy Chief Huffman. So in the context of the Minneapolis Police Department, we do not view coaching as discipline. It's really designed as an employee performance tool. Within the MPD, and I've certainly laid this out in my vision statement, and I've said this publicly on the record, probably the most influential position within the Minneapolis Police Department is that of a sergeant or a supervisor. I expect our sergeants, our supervisors to truly be that, to be coaches, to be mentors. If they were only utilizing discipline, it would truly diminish the value and the worth of that position. We expect all of our employees to grow, to learn, to improve upon their performance, and to really hone their skills to being leaders. And so coaching has been the bedrock in being able to do that. And I say that again, that it's about learning. Our workforce comes from our society. We know that our society is not perfect, and I know that I'm not inheriting perfect individuals within the workforce. That being said, we want to continue to improve upon their skills, improve upon their performance, so that we have the best peace officers that we have within the department and that our communities can expect for that. Some of the day-to-day examples, and I'll certainly have Deputy Chief Huffman talk about it, her most recent position as a precinct inspector, but coaching can be about helping an officer to improve their report writing skills. Coaching can also be to address an officer's attitude, as well as help with training. We are a city enterprise department that has a lot that is asked upon our employees in terms of state mandated required training, post-board training. We have a lot of internal in-service training that is required of all of our employees year to date. We have and certainly Director Ferguson knows about this, we have a very fluid and dynamic workforce, in a generational workforce. Technology, for example. When I joined the department, we did not have the technology tools that we do today. We need to make sure that our employees are all versed on that, honing their skills. That being said, we also want to make sure that our employees are not just relying solely upon the technology, but they're having those face-to-face interactions with our community as well. Some of that could be, some communities members may think that, well, if the person's not giving me eye contact, the officer's not giving me eye contact, that they may be rude. Coaching could be a situation like that where the supervisor sits down and talks to those employees and talks about the importance of making sure they have that really respectful engagement with our community so that they feel that their voice is being heard. Our MPD policy 2-112 outlines the non-disciplinary coaching process, which has also been consistent in the language of our discipline manual and matrix system. I will turn it over real quickly to Deputy Chief Huffman to talk about how that process works with our joint supervisors of OPCR. DC Huffman?
Thank you, Chief. So the process that we have in place now for these coaching referrals generally begins with the intake investigator. The intake investigator will collect all the available evidence about a complaint. That can include things like the body-worn camera video, reports from our reports system, call logs through our CAD system, and they'll put all of that together for review by the joint supervisors. The joint supervisor team is made up of the director of OPCR and our commander of the internal affairs unit. And those two meet weekly to review all of the cases that are currently in the queue and make decisions about how to proceed. So after they review the evidence that has been collected, they determine whether a case appears to be one that is appropriate for coaching. In our policy and procedure manual, which I know many of you are familiar with, you'll see that some of our policies and procedures outline levels of potential discipline right there in the policy manual. And those things correspond to notations in our discipline matrix. So only the most low-level policy violations would become eligible for coaching referrals. As Chief Arredondo mentioned, often this is things like errors in report writing or the quality of reports, engagement with folks when our officers are providing service, seatbelt violations, and driving violations related to minor crashes with squad cars. These kinds of things are eligible for coaching because they're really within that area where we're looking at improving our employees' performance, really trying to train, refresh on policy, provide additional supervision, mentoring support, and sometimes to things like health and wellness or employee assistance. So once the joint supervisors have reviewed the case and determined that it is appropriate for coaching, they'll send that case file and some forms to fill out. That will go to the employee's direct supervisor, who will look at it, review all the information that has been collected, do any additional investigation that's needed to determine whether there's enough information to sustain that a policy was violated and that coaching would be appropriate. And then they do that coaching with the employee, and they document that on our coaching paperwork within a 30-day time frame, and then send that information back to OPCR so that we can retain it on file. So while A violations are not considered disciplinary, repeated policy violations at the A level are eligible for enhancement. And so 2 A's within a 1-year reckoning period that are same or similar violations, or 3 violations in any period of a year, then become a B level violation, which is disciplinary and is subject to then those penalties that we talked about elsewhere in terms of written reprimands, suspension, and so on and so forth. And repeated performance issues can be eligible for discipline up to and including termination. So even though A-level violations are our lowest level of non-disciplinary coaching for performance improvement, we do recognize the possibility that if those violations do continue, we would need to address them in another way. So that is a quick overview of how the coaching process is applied. We've had about 741 coaching referrals that were made since 2013 when our current dashboard began keeping track. And about 31% of those have resulted in a supervisor determining that there was some coaching for performance improvement that was needed. So if you have any other questions about that, I'd be happy to field them.
Thank you, Chief and Deputy Chief. We'll go ahead if there we have some time for questions at the end of the presentation here too. So we will go ahead and move on to the next slide here. Ooh, there we go. Perfect. And I will go ahead and hand it off to City Attorney Jim Router and Assistant City Attorneys Trina Chernos and Joel Fussy to give a legal overview of how coaching is viewed both here at the city and under state.
Thank you, Chair Abdi, members of the commission. My name is Jim Router, and I am the still relatively new city attorney here in Minneapolis. Been here since the end of August of last year. And I certainly understand this issue has been discussed on more than one occasion, even with this commission and with input from our office. I think before I hand it over to Assistant Attorney, City Attorney Chernos, because she has in our office has certainly been the closest and the closest thing we have to an expert on this issue, as she works closely with the HR organization and with the NPD. I thought it might be helpful to give a bigger perspective from, again, I am new to this role, but for more than 25 years, I was the chief labor and employment lawyer for one of the largest employers, not only in the state of Minnesota, but in the United States. And I just think it's important to underscore what we've heard from Director Ferguson and from Chief Arredondo in the sense of coaching is essentially for just about every employer the only example of non-disciplinary guidance or corrective action, for lack of a better word, that any supervisor can give one of the members of their team. And I think we just have to realize that without the ability to coach, as the chief said, sergeants who are his most important and critical leaders, there's no ability to be a mentor, there's no ability to be a leader, and there's no ability to be a supporter or developer of the people that you actually supervise. And ultimately, that would just leave supervisors in a position of really not having any role other than to give direction and then walk away from the very employee of theirs on their team that they're there to actually guide. They would really have no other interaction other than when it's time to actually engage in some disciplinary activity. So I thought I would share with you that perspective for somebody who certainly has been familiar with this space with regard to employers throughout all industries that I'm aware of. And with that, I think I'll hand it over to Assistant City Attorney Chernos to dig into the legal issues, particularly with regard to coaching at the city and the implications some of these legal nuances can have. Thank you.
Thank you, Jim. Vice Chair, Commissioners, thank you for your time and your attention to issues, especially regarding policing and your service on this commission. I just wanted to start off by explaining some of the legal nuances related to coaching. And I'll start with the fact that the state legislature defines classifications of data, and then our office advises on the law as we understand it with respect to those definitions. Some of the other state laws that come into play here more specifically. So as many of you probably know, the Data Practices Act is the state legislature's attempt to balance the public's interest in governmental activity with certain privacy rights of public employees. Specifically, as this relates to this topic, it's important to note that the state legislature has determined that final disposition of discipline is public. And as the Chief Human Resources Officer explained, and the Chief of Police and Deputy Chief, that in the city, coaching is not discipline. It is a different type of manner to try to correct employees' conduct. Another state law that comes into play with respect to disciplinary actions is found in the Public Employment Labor Relations Act, which mandates that public employers have a grievance procedure for written disciplinary actions. Another item to note here is a local law that relates to coaching, and that is found in the city ordinance on civilian oversight. And it discusses that A-level violations within the police department may result in coaching. Although, as Deputy Chief Huffman aptly noted, there are occasions where a multitude of lower level violations, if they start to compound, may result in discipline. For a detailed analysis about the interplay between these laws and the city and coaching and where it has defined coaching as non-disciplinary, I would encourage anyone interested to see the legal opinion that our office provided in September of 2020 in response to the then chair of this commission of the PCOC. And I'll just conclude by stating that coaching of employees is not public because it is not disciplinary, let alone reaching final disposition of discipline. And I know, as Mr. Jeffries indicated, there would be time allotted at the end for questions with the acting chair's approval. Thank you.
Thank you, City Attorney Router and Assistant City Attorney Chernos. I think we can go ahead and now move to the next slide and open it up for questions and answers here for anything that the commissioners may have at this point.
Are there any questions from the commissioners or discussions on this presentation? Commissioner Sarah?
Thank you. I have several questions, and I'm not sure who would be the best to answer, so hopefully you'll just choose. So my first question is just really basic. What is discipline? Could I have a definition of that?
Yeah, sure. I think Patience, would you maybe want to start? And then I think this is going to be consistent across city enterprise. We can start with Patience and then go to Trina as well.
Commissioner, what discipline is, and I think I was either Chief Rondo or DC Huffman alluded to that, is when you have made several attempts through the coaching process to try to work to get a behavior changed, and all of those have been exhausted, then based on whatever that particular situation is, then that may be an option for an employer, a supervisor to take as a next step. And so that is an overview of what the disciplinary process is. And then I would like to open it up to Chief Arredondo as well as Assistant Attorney Chernos.
Yeah, thank you so much, Commissioner Sarah. For me as chief, discipline would be something that an action or conduct by one of my employees that was significant enough that it either violated policy or procedures or certainly went against the values of our department. And so obviously there's a process that's in place through the OPCR. If that investigation ultimately gets to me and the merits are there, then I would make a decision in terms of disciplining that employee.
Commissioner Sarah, if I may add to that, there are at least two places where we would look for that definition, and one is the Civil Service Commission rules, which, and I addressed this in the opinion circulated in September, but for those of you who haven't seen that, the Civil Service Commission rules 11.04 address and define what constitutes discipline within the city system, and that includes written warnings, written reprimands, suspension, demotion, and discharge. And then the second place to look, given that the primary focus here, at least with respect to the authority of this commission, I should say, the Federation labor agreement could come into play here as well. And it does not lay out the, what is discipline, at least the way that you framed your question, but it does indicate that the following actions by the police chief would be subject to the grievance procedure that I had mentioned is mandated under state law. And those are a suspension, written reprimand, demotion, and discharge.
Thank you. Vice Chair Abdi, I have several questions. Would you like me to sort of just get back in queue, or how would you prefer me to sort of go forward?
I think you should keep going because I feel like a lot of us might have the same questions.
Very good. Thank you for that. Well, sort of an immediate follow-up to sort of what is discipline, and thank you to the three speakers for that. I'm looking at the civil service rules right now. I'm looking at 11.04, which Attorney Chernos just guided us to. And that does describe the kinds of discipline. And under 11.04A is a warning. And it says a disciplinary warning, so that would be discipline, includes a verbal discussion between the employee and the supervisor covering the details of the problem, plans for correcting the problem, and a written memo to document the event. And based on Attorney Chernos's memo from September, that is precisely what the coaching process is within MPD. There is a verbal discussion between the supervisor and the focus officer. There's a discussion of what was the violation, what's the plan moving forward. And then there is a coaching documentation form that must be filled out. And that form is attached as the last 3 pages of Attorney Chernos's memorandum. I believe it's pages 35 through 38 of the PDF document. So I'm just trying to understand that is identical, that process is identical. And simply stating something is discipline or not discipline doesn't automatically make that, true under the law, particularly if it does everything that discipline does. So perhaps someone could speak to that and explain the distinction between a warning under the civil service rules.
Thank you, Commissioner Sarah. I think if we want to start with Trina, Assistant Attorney Chernos, and then maybe move into MPD and maybe HR, get HR perspective as well.
Thank you, Vice Chair Abdi and Commissioners. I can certainly understand that all of the Civil Service Commission rules, ordinance, things are subject to interpretation. In the city, we have a practice of trying to always make sure that an employee leaves a conversation understanding, whether discipline has occurred or not. I want to really emphasize, and I think this is really important to understand, is that there is no obligation to document coaching. But the MPD utilizes a coaching documentation form in part for accountability. And I'm sure that, DC Huffman and the chief could probably, explain this better than can I. But it's a way to make sure that the supervisor who had the conversation with the employee documented that, but it wouldn't necessarily go into the elements that are in 11.04 warning, which includes details of a problem, plans for correcting the problem, and a written memo to document the event. The coaching document is more to indicate that it occurred and that the case was resolved or proceeded under the city ordinance with respect to category A level violations and coaching. Written warning, as is set out in the Civil Service Commission rules, is for something that is actually disciplinary, and the document would be different. We use in the city either the chief's discipline memo for the MPD or what's called a determination letter in the city. And the subject line of that document indicates, or elsewhere in the body of that letter will indicate what is being imposed with the employee, and will indicate that it is a disciplinary measure. And then the key part of that, which is very different than the coaching document in the MPD, is that it will state at the bottom that further misconduct will result in discipline up to and including termination. And that's not what coaching documents under either the MPD system or other labor agreements within the city system would show.
Thank you, Assistant City Attorney. If we want to go ahead and hand that off to Deputy Chief Huffman, if there's anything to add from the MPD perspective, or to patients, if you want to add anything from the HR perspective.
Thank you. In terms of the MPD perspective, I mean, I think for us, there's a really significant difference in how we approach coaching or performance improvement than how we approach discipline. In terms of the timeliness of it, we're able to handle coaching referrals much more quickly than we do disciplinary cases, because disciplinary cases require a much more significant investigation in order to handle those and prepare for potential grievance or arbitration that would come out of a disciplinary proceeding. And so we do focus on getting the coaching referrals through the system as quickly as we can and out to the supervisor. And they don't require the kind of lengthy statement taking and written reportings, because they're not disciplinary. So we can really focus on a supervisor connecting with the employee, building that relationship between the supervisor and the employee, looking for ways to set expectations for the outcome, looking for opportunities to provide coaching and also support, having conversations about what might be at the root of the issue for the employee, whether it is a need for more training or more support, or it's looking at re-engagement or reinvigorating the employee, or making some other kinds of changes in support of better outcome, supporting better decision making. There's really a whole host of possible outcomes. But at the end of the day, those outcomes are not grievable. And so we're able to really provide that kind of intervention without going down that very adversarial pathway that we do when we have a disciplinary case. So that's one fundamental difference between those two pathways. And then I can turn it over to Patience Ferguson for some additional information.
I do not have anything to add to what has already been said. Thank you for the opportunity.
Thank you. Then I actually have a question. I believe it's for Director Ferguson, but perhaps Director Ferguson and Attorney Chernos. It sounds like there's two different things that are called coaching. It sounds like within the HR department, there's coaching that is informal, spontaneous, and it's used more or less constantly between the supervisor and the employee. And that's one coaching. And then within the MPD, there is this other thing called coaching, which we've been talking about here today, which is a very regulated process. It is not spontaneous. There is some sort of complaint or observation or escalation, and then there's an investigation. And then if the investigation is sustained, or it looks like that misconduct occurred, then there is this very regimented coaching process. And there is, of course, the coaching form to be filled out. So that seems like two very separate processes.
Thank you, Commissioner Sarah. Assistant City Attorney Trina Chernos, do you want to go ahead and start, and then we'll move over to patients?
Yes, thank you, Vice Chair and Commissioners. With respect to the comment or impression that coaching is very regimented, I just wanted to clarify that One of the differences between coaching and discipline would be that coaching can occur long before the coaching document is filled out. In other words, the supervisor could have a conversation right then and there with an employee. It wouldn't even need to necessarily go through. Actually, a coaching conversation could occur before a formal complaint is even submitted. So that's first. And then another aspect to this would be that unlike a conversation that might lead to discipline, there is no right to a union representative present during that conversation. One of the statutes that I didn't mention at the outset, just trying to keep this simple, is the Police Officer Discipline Procedures Act. And that also needs to be taken into account with this. So, you know, if the MPD could not have more casual conversations right in the moment and without a really regimented structure, that would delay being able to take action with that officer and would require all the formalities that are set forth in that Peace Officer Bill of Rights, or the Discipline Procedures Act, as it's officially titled.
But isn't that different when there's a sustained complaint? So there's been this investigation and it's sustained, and then you're doing the coaching. And within the city, 90% of sustained complaints result in coaching.
Not necessarily. As far as I think, as I'm understanding your question, please feel free to correct me if I'm misunderstanding it, which is that not every sustained complaint must result in discipline. In other words, not every sustained violation of the MPD policy and procedure manual would result in discipline.
And that's a change, isn't it? Because, let's see, section 5.5-101.02 of the MPD manual said that discipline shall, operative word shall, be imposed following a sustained violation. And that was removed in, I don't know the date. I think it was removed December 31st of 2020. So it was removed very recently. Why did the city remove that requirement?
The MPD policy and procedure manual was revised to clarify its existing and documented policies and procedures and practices. And, you know, understanding, and I had addressed this in the memorandum from the city attorney's office back in September, which is that once the city knows that a provision is subject to misinterpretation, then the city proactively went about working on revising that policy to avoid misinterpretation in the future and to align it with all of the other writings that indicate coaching is not discipline. And when the announcement went out, it was explained that it was a clarification. And that it was inaccurate, that not all sustained violations had to or were resulting in disciplinary action.
So the intentional policy of the MPD is there could be a sustained violation, and it is possible that it intentionally would not result in discipline, not even a warning.
So, and I don't want to speak for the police department here, and I'm just trying to refer to some of the documents that were attached to the materials back in September. And as the MPD's discipline matrix indicates on the last page of that document, which is attached to the legal opinion, that that based on the category level in there, that could mean that it's not a disciplinable offense. So it could be a sustained violation, but a violation of a category A level, just as the ordinance indicates.
The schedule of discipline that you included in your memo, Attorney Chernos, it indicates that coaching is available for all levels of misconduct, A through D. So a very serious misconduct, such as excessive force, could, under the schedule of discipline, result in coaching, which as you know, everyone on this call has explained, is not considered discipline and thus not public, and you know, like all of that. So, can you speak to why all levels of misconduct and thusly all sustained complaints would not be subject to any level of discipline?
I think that's a better question for the police department to address how they approach their matrix and how it works in practice.
Thank you, Assistant City Attorney Chernos. So if you take a look through the matrix document that we have, you'll see that many of the policy violations here corresponding to what's in our policy and procedure manual are defined with ranges that do not include A violations. And so those are not policies that we would send into the coaching referral process. So during that initial meeting between the Joint Supervisor Team, the Commander of Internal Affairs, and the Director of OPCR, they're taking a look at what is in the complaint and what evidence the intake investigator has been able to gather, and making a determination about whether there is a policy violation that would not be subject to coaching, that's not part of those A-level referrals. Because as you'll see, if you look at the discipline matrix, many of our policies and procedures are identified specifically with ranges that do not include A violations. So for example, everything in the use of force category does not include an A-level referral as a possibility.
But under the schedule of discipline, it specifically says a D-level violation could have a range of coaching all the way through termination.
So if you take a look at our matrix, when you see the ranges, many of them are only D or C to D or B to D. Some of them specifically do not include A referrals.
Oh, so tell me if I have this right. If it's something, let's say a body camera something violation, and that says A through D, then since it's possible to be an A level, that is the thing that makes it eligible for coaching on your schedule of discipline. Is that right?
Yes, that is correct.
Okay, so under your understanding of the matrix, something like excessive force would not be eligible for coaching.
Yes, that's correct.
But Derek Chauvin committed multiple acts of excessive force, and he was coached for it.
So I can't speak to the specifics of those cases because there are ongoing investigations and litigation around that. So in general, I can say that our policy is written with the intention to only refer things for coaching that are considered to be low-level violations. And so force violations, use of force violations themselves are not included in those coaching referrals.
Then does anyone on the call have information about why Derek Chauvin was not disciplined for multiple instances of excessive force?
I think as Deputy Chief Huffman had said, that there is a lot that goes into this process and what we legally can and cannot say. And I think Director Ferguson, I think wanted to chime in here too.
Yes, thank you very much. Just another, I know that it seems like we're going down this path with respect to MPD. But I also want to make sure that we're looking at the broader picture of how we are doing this from an enterprise-wide perspective. And so we want to also look at this in context of how this is viewed in the enterprise. I think that's really important just to reinforce. And it was my understanding that we were going to be looking at this specifically around the enterprise perspective. Am I not clear on that? Or do I need to get more understanding around this? Because it seems like we're going over here and beginning to use one specific example. And my concern is that are we being consistent in terms of coaching, or what we're trying to do is say in some way that the city, and bear with me because I'm very new to these meetings. So please take this in the context and the spirit that it's being given. When I look at things, I'm looking at things from an enterprise perspective, but it seems like now we're going specifically down this path. And so I need a little bit more clarity around this. Is there something that our city attorney can provide some more clarity around so that I can get a better understanding? I think that would be very helpful.
Well, Director Ferguson, just from my line of questioning, I'm trying to understand coaching at the enterprise level as, just like coaching and what that means and wrap my arms around it. And in order to do that, I think it's really important to understand some specific examples. And I mean, it's natural to pull out the most egregious specific examples. And so that's why I called out Derek Chauvin beating a juvenile over the head with a flashlight and rendering him unconscious and kneeling on his back. And that was excessive force. And he was coached for it. He wasn't disciplined. And I think that's something we need to contemplate in this discussion around coaching. And I see a lot of my colleagues also have questions, and I don't want to, take the oxygen out of the room. So I'm gonna let my other colleagues step in here.
Thank you for your questions, Commissioner Sarah. Commissioner Pino.
Yes, I had a really interesting question for I'm sorry, I don't remember your title. Please forgive me, Ms. Huffman, if you are available to speak. And you mentioned particularly timeliness in regards to coaching versus discipline, and I think that's something that, at the end of the day, the definitions confuse me. They're not just confusing to anyone else who isn't saying it and just thinking it. They confuse me as well. The thing I care about is that when there is some sort of violation that is sustained, and the city, in some level, takes efforts to correct and learn from said sustained violation, that we do so in a way that is both timely, transparent, and effective. And I think, at least I hope, that is a shared intention for everybody who's on this call. And you mentioned this idea of coaching is able to be more timely than going through the full discipline process. Could you speak as to why that is the case? Like what are the actual procedures, the mechanisms, the paperwork, anything that is the difference between some, decision of coaching versus the extra mile, if you will, to discipline?
Sure, that's a great question. I thank you for asking it. Hopefully I can give you a pretty good answer.
Mm-hmm.
Coaching as a process and administrative investigations that can result in discipline are two very different animals.
Mm-hmm.
So when we look at coaching, hopefully that is the most timely process we have. I mean, ideally, we would really like to have the shortest possible lag time between a supervisor recognizing that there is something that we would all benefit from investing some coaching in, or the department receiving a complaint to let us know that something happened that we need to take a closer look at and talk to our employee about, to really get to the bottom of what happened and hopefully orient everyone on the correct solution going forward.
Mm-hmm.
It's not as instantaneous as we would like, of course, because there is a procedure that takes place. Generally, how long that process takes is governed by sort of the amount of workload that's coming into the pipeline. Every week, the joint supervisors meet once a week. They have several hours set aside to just review cases that are in queue. So those are complaints or referrals that have been received either from internal city enterprise folks, other department employees, or members of the public, and whatever information that the intake investigator has put together. And then they make a determination about whether it is appropriate for that to go out to coaching or whether it's going to go into the pipeline for a full administrative investigation. So if it goes into the coaching pipeline, then essentially the investigation that happens before the conversation with the employee is quite short, because we're not taking all of the steps that we would in an administrative investigation, which would include taking very formal statements from a complainant, from everyone who might be a witness, from the officer who is alleged to have committed the violation, from other department employees, potentially from subject matter experts inside the department. So, that can be quite a big undertaking for us. The scheduling of those interviews takes time. Typically, we do them one after another, with the focus officer being the very last interview, so that you have as much information from the investigation, all of the witness statements, subject matter expert statements, the evidence from reports, from body-worn camera, other kinds of physical evidence that might be collected in the case, or video evidence from outside sources. Really, it's sort of parallel to a criminal investigation in terms of the kind of evidence that you might be collecting. So that can take many months to complete before you take the final statement from the focus officer, and then that case goes to a panel made up of 2 civilians and 2 sworn staff from the department. They review the investigative summary and the evidence that was collected, and they make a recommendation to the chief about whether they believe that there is merit to the allegation or not. And then that case will come to the chief's office for review, and we do some additional processing on this end in terms of giving the employee an opportunity to provide some more information to us before the chief makes his final decision. So there are a lot of steps in that process, and it can take quite a long time.
Okay.
Coaching, on the other hand, gets a review at the beginning by the intake investigator and a referral into the coaching pipeline, and then immediately is at the point where the officer's supervisor is sitting down with them and talking to them about what happened. And we like to have that happen within 30 days. So the timeline in comparison can be much shorter and much more direct than in a disciplinary investigation. Which, after all of those steps in the investigation, those things that we need to have happen so that we can hit that threshold of showing that there's just cause to discipline someone, that there was an investigation that was thorough, that was fair, that proof was really collected, that the violation occurred. And then we can go into the grievance procedure after that. So that drags the timeline out even longer. It's a grievance period where people have an opportunity then to file their grievance. We try to negotiate the grievance. If we can't negotiate the grievance, then it can get scheduled for arbitration. That can drag on, preventing us from reaching that final disposition stage for sometimes more than a year after the case has already been completed for an administrative investigation. So the timeline for discipline can be much, much longer than the timeline for coaching.
Okay, thank you.
But hopefully it helped a little bit.
It was a long answer, and my second question, I hope, picks at some of this, because I feel like, and correct me if I'm wrong, there are multiple entities that have stake in the game along that process that you described for us, that have had different ways in which they've either negotiated an agreement of how that procedure has come to be in its current form, or there is some other standards either internally with MPD or from the state, but I don't know that to be sure. Could you explain to me, for the discipline process, itself, who mandates what stages of that discipline process? And is it coming internally with MPD, or is it coming from external source, or is it negotiated at some point? All the way from, you found that it's not going to be coaching, all the way through, oh, I wish I remembered the phrase that you used. Past arbitration.
Yeah.
Could you give us the entities that are involved in that and that are mandating each part of that process?
Yes, that's a great question, and I'll make my answer much shorter this time. That all of those things you said play a role in it. So there are externally standards that we have to meet in terms of the law. There are internal things that we have to hit because we have negotiated agreements, and we have policies and procedures. And then we also know that we have the potential for these cases to go to arbitration. And so we know we need to be able to show that we have handled the process correctly and the investigation is thorough and strong enough so that we can hopefully survive an arbitration. And I'm sure that Assistant City Attorney Trina Chernos can weigh in with some additional information that I have no doubt she's chomping at the bit to provide about how those components work together to create the system that we have for those administrative investigations.
And if she is not able to speak on this matter, I would love for, and excuse me for forcing to be a little bit more explicit, just so that way, in case we don't already know, could you tell us the other entities that are involved? Like, I mean, the state laws are obvious. City level laws are obvious, but when we talk negotiation, are we talking with union contracts? If so, which unions? Are we talking with other core standards that are shared amongst municipalities? If so, what core standards? If you could give me like names of these so that way I know the bodies that are involved.
Sure. And I think Trina will probably give an even more complete answer than I can, but certainly state law, some of which has been referenced before, 62689, the Peace Officer Discipline Procedures Act. We have PERLA, we have civil service rules, we have the contract that the police department has with the Police Officers Federation for city enterprise. I'm sure Director Ferguson can weigh in as well about the other labor contracts, but all of those contracts have language in that. And then of course we have arbitration and what the standards that we know are necessary for us to be able to show that there was just cause for discipline, which is the magic language.
Yeah. Okay. And then I guess my final question is, there seems to be, in the year that I've been involved and exposed to this idea of coaching versus discipline, this idea around, and pardon me for being frank, it's just I'm the messenger here, that coaching is not transparent enough, and it is a tool that could be used for less than ideal purposes, and therefore we need things to be out into the light in an effort of transparency. On the other hand, what you just said here today was coaching is a really useful tool to make sure that we're having effective learning moments and corrections that are at least able to be responded to faster than the discipline process that you explained. It may be a naive opinion. Why can't we have both? And having both the transparency that that members of the public tend to have a concern about versus the timeliness that you have explained behind coaching. What is the barrier that's limiting this process to allow it, whatever it is, whether you want to call it coaching or discipline or whatever, the response to sustained violations? What's limiting us from being both transparent and timely?
Sure. So a couple of things probably in terms of the timeliness. Disciplinary investigations, administrative investigations take time. We only have a certain number of investigators, either on the internal affairs side or the OPCR side. We're very fortunate that the mayor's budget did allow for some investments on the OPCR side to bring the number of investigators up. That will reduce timelines. But nonetheless, having done this kind of work myself in the past, these things just take time, more time than coaching will take. So to get an administrative investigation to be as timely as coaching is probably not realistic. And in terms of transparency, then we're back to talking about data practices law.
Is there anything, and I am not a lawyer, I've been told multiple different perspectives on this that I'm sure we could go into if we wanted to. Given we cannot change state law unilaterally here in the city, is there something feasible we can do to adapt to the way the data practices law is now, but try to reach that transparency goal that it seems like there is an interest in? Or is that just not happening?
I think that if transparency were our paramount goal, you might find that we would have other significant downsides to that would that people would find to be significant downsides. So
such as
if we handled every case as an administrative case to run through our official discipline system, you know, the timelines for every case, including the serious ones, would grow longer because we would be doing a full administrative investigation on many, many more cases. And so it would just take longer for everything. At the police department at this point in time, we simply do not have the staffing numbers available to massively increase the size of our internal affairs investigative unit. And OPCR doesn't currently have the budget to massively increase the size of their investigative team. So we wouldn't be able to then shrink those timelines back down by simply providing more people to do that work. And then even if we did, you know, if we were successfully able to address that issue, we would also then have an issue that every single one of these cases would now become grievable. And so that final disposition for discipline would be pushed out. We would be pushing many, many more cases into the arbitration system, into the grievance system. Those timelines would get longer, and we would not reach a final disposition in anywhere near the timeline that we're looking at now, which is already long. And many of those cases would not be decided in our favor. Just statistically, you know, we win about half, maybe a little more than half of those cases. Ideally, that will get better over time now with some investments that we're making and some changes in the arbitration system. But at this point, I think those would be pretty significant downsides.
All right. Well, thank you very much. I'm going to hold off on the rest of my questions and yield the time to my colleagues. Thank you so much.
I'd just like to make a quick comment regarding the transparency piece related to coaching. And it gets back to a question I had a few minutes ago, that we are also looking at this from an enterprise perspective. And so if we're looking at an enterprise-wide perspective regarding transparency and coaching, it's not just involving the police department. We're now talking about 4,000 people within the city of Minneapolis who we're working to develop, grow, enhance their skills. And so then I'm going, you know, just the question was asked, what would be wrong with transparency? And I'm just not talking about the discipline piece. I'm specifically talking about the coaching piece. And so now, say that was open, we still, as an enterprise perspective, and that's what I'm bringing to the table, that means that 4,000 employees would also, if that in some way was taken into consideration and that law wasn't there, that's regarding looking at our future workforce, that every single time a person was coached, that is creating somewhat of a, possibly, I should say, a disconnect between someone who's really trying to grow and trying to develop, but then knowing that that could potentially open that up to a lot of other things. So I just wanted to bring that. I'm always going to be looking at things from an enterprise. I know that this is specifically maybe looking at more narrowly focused for police, but what impacts one particular department in the city also could potentially impact the other 21 departments in the entire enterprise. So that's just a comment and just a thought.
Thank you. I just want to thank everybody for asking their questions. I wish we could continue this conversation. I have a lot myself, but unfortunately we have to move on. But thank you, and thank you for our presenters. With that, I will direct the clerk to receive and file this report. We'll now take up the case summaries. Oh, okay. Actually, it's reports. So I would like to recognize Commissioner Sarah, who will present the Policy and Procedure Subcommittee report.
Okay, thank you. Hi, everyone. We had a great Policy and Procedure Subcommittee meeting, yay. Two excellent topics that we discussed. The first was traffic stops or pretext stops, and the second was a presentation from Councilmember Gordon about, I'll call it a framework for changes to police oversight. So taking the two in turn, we had a presentation from an attorney, Jay Wong, utilizing MPD data from the dashboard on traffic stops in the city of Minneapolis. And that's available on our agenda. Basically, what I can say about those numbers is that they were really staggering. The racial disparities in the number of who was stopped, who was searched, who was pulled over was, even for someone who's done this work for quite some time, it was staggering. Black and East African people are more likely to be pulled over by a factor of 10 than other people in the city. And so essentially what he provided us with was this data that something needs to change around these pretextual traffic stops. And one thing that we discussed within our group was some proposed language to limit traffic stops or pretext stops. This language came from the Minnesota House of Representatives. It was authored by Representative Frazier. It was ultimately included in a larger public safety omnibus bill that did pass the House and is currently before the Senate. And so we as a group voted unanimously to escalate that language to this group, to the full commission, to vote up or down whether we should send that language to the council and the mayor and suggest that each of those bodies take action. So in the case of the mayor, what the mayor could do along with the chief of police is to voluntarily adopt that language as the MPD policy. So even if it didn't pass the Senate this year or it passed in a different way or, you know, whatever happens with the state Senate, the city, the mayor could choose to make that the city policy to limit traffic stops and pretext stops to extremely limited circumstances that involved safety. And as far as the city council goes, the city council could do a couple of things. One, they could refer it to their IGR, Intergovernmental Relations Lobbyist, and ask them to support this omnibus bill before the state Senate. The council could also pass an ordinance that either mirrors this language or picks up part of the language or, you know, does something around that. And the council could also report to the, or give a direction to the city attorney's office, the prosecutors there, that they don't want the city to prosecute offenses arising out of those kind of traffic stops. So, you know, like the mayor and the council have different roles within the city, but they each could take some action. So I think before I move on to the second piece from Councilmember Gordon, I should maybe stop and welcome any questions from the other commissioners who weren't part of that subcommittee. Commissioner Jackson. I mean Pino, sorry.
It's all good. Yeah, I'm looking at the presentation, and just because I have to ask, did Mr. Wong provide a methodology behind these the data within his presentation? I don't see it here. And I feel the need to ask from an audit perspective. I would love to look at the methodology behind it. I'm sure it's pretty straightforward in an Excel table, but do you know if you have that?
I don't remember him using the word methodology.
Mm-hmm.
He described gathering the data from the MPD dashboard,
Mm-hmm.
and you know, putting the numbers together. And he looked at different timelines. So he looked at timelines leading up to the murder of George Floyd, and then a period of 6 months afterwards, just to see if there was a change. And he controlled for other factors such as the total number of stops. The total number of stops were reduced during the pandemic for like all these reasons. But even when the total number of stops were reduced, the rate stayed the same.
Mm-hmm.
So like the percentage. So I don't remember him using the word methodology, but he those were things he used to describe what he put together.
Yeah, but no like written documentation of like the original data source he pulled from, the ways in which he cleaned up the data and then applied that, and then kind of like the rough draft, if you will, of like constructing the presentation. Did he like follow up with anything like that?
He didn't
by
provide
chance?
any additional documentation. I'm sure we could ask him. He's extremely, available. He said his source of data was the MPD dashboard.
And he noted as such on the PowerPoint, which is a great starting point. I would just love to see how he got from A to B, and it's the only like quirk that I have about it, of just like, it's the equivalent right now of like, in math when the teacher says, show how you got your answer. Like we have the answer, but we don't know how he got to the answer, and would love to just look at that.
I can send him a follow-up email if that would be helpful.
Yeah, I mean, if you could, that'd be great. Yeah, just we're an evidence-based group, right? And I want to make sure before we put our name on something that we're at least making sure we got a cursory look on how that evidence came to be. Not that I'm doubting it at all. I would be surprised if he made a mistake, but I just,
I believe that he reported it to the Star Tribune last summer, perhaps August, and the Star Tribune verified the data at that time.
Oh, cool. Okay.
And then he provided us sort of that updated piece, like the 6 months following that August. So I don't know. Any other questions about the data or this language that we voted on? In such case, I'll make a motion to the full commission. I move that the chair of the commission, or the chair and the vice chair, share this language with the council and the mayor, and encourage them to take action at the city level to adopt or amend and then adopt this language, this policy for the city of Minneapolis.
I will second. Commissioner Sylvester.
Any discussion on the motion? Does the clerk then take roll if it's been seconded?
Yeah, this would be an act of the PCOC. So if this is an action of the PCOC, we need a roll call in order to verify that this was a formal act approved by a majority of the commission.
On the motion, Commissioner Sarah?
Aye.
Commissioner Crockett?
Aye.
Commissioner Jacobson?
Aye.
Commissioner McGuire?
Aye.
Commissioner Pino?
Aye.
Commissioner Sparks?
Aye.
Commissioner Sylvester?
Aye.
Vice Chair Abdi?
Aye.
There are 8 ayes.
Thank you. And we did have one more piece that was discussed during our subcommittee meeting. It was a presentation from Councilmember Cam Gordon. He did include a 2-page document that I shared with the commission, that it was not a proposed change to the ordinance. It wasn't like a hard, ordinance language. It was rather a framework that he is using to guide his discussions around potentially changing the ordinance for police oversight. And what he offered to us as a commission is that we could do a couple of things. We could sort of, vote to like approve this framework and, give him a thumbs up essentially, and give him that backing. We could, he offered that we could take this and, have our own commission meeting on it, or have an additional special meeting about it and invite public comment, or, do what we would. I think both are good ideas. I think that he took the time to come to us with this presentation. We discussed it in our subcommittee, and we all thought it was consistent with our goals and with the national standards for civilian oversight. And we thought this framework was positive, and we endorsed it, and we would like the full commission to endorse it. And I think there's a lot of opportunities here for us as a full commission, whether we want to have, a special meeting or invite community comment at a future meeting, or, with it in that way. I think there's a lot of opportunities there. I see a hand from Commissioner Pino.
Yeah, I just remember we have an ad hoc ordinance committee, right? Do you think that this might be something that would be a beneficial conversation within that context?
Yes, and my understanding is that subcommittee is not meeting, but
Yeah.
it could meet at any time. So perhaps this is a good time to, bring it back to life, as it were.
I'd be happy to move and refer this to that committee if that does not raise any objection with anyone.
Commissioner Pino, it's Casey. I just have to ask, are there members appointed to this ad hoc committee, or do we also then have to appoint members to this committee?
I do believe that would be an answer for our chair, who is not present. I'm not informed well enough on the membership of that ad hoc committee.
When I was given the list of subcommittee membership by the chair, it did not include the ad hoc committee. So I'm guessing there is not membership at this time.
My recommendation is to expedite any action. You keep it within one of the two existing subcommittees. Since those are formed, they have members and they have meeting dates.
Thank you. Commissioner Pino, I wonder if this is perhaps best to stay with the PMP subcommittee, in that it's not a quantifiable research project that would be audited, if you understand my meaning. But I
agree. It's more germane within policy and procedure, but I'll yield to our vice chair and the clerks to make the decision on that, on the point of germaneness.
Seems like the co-chairs have concurrence that it stays in policy, which seems to be a broader subject matter area rather than audit.
Thank you.
I agree.
I'd like to make a motion then to the full commission to vote yay or nay on whether we endorse this framework, and that would just be a basic endorsement, like yes, we agree with this, or no, we don't. That way we know if we should be doing a lot of work on it in the subcommittee. That would send a message to the council, like yes, this is good, or no, it's not. I would really just like to have sort of an up or down vote. So I would make a motion on endorsing this as a full commission.
Point of information, is there, if we're voting on this, do we need to refer to it to a subcommittee, or are we just going to go through the discussion and vote on it now?
I think if we took it to a subcommittee, that would be for further work, as this is a framework. The subcommittee might propose an actual ordinance change, like adding subsection B to 170. You know what I mean? This is more of a framework.
Commissioner Sarah, so my understanding of your motion is that this is a vote to endorse a concept, or as you used, a framework of a plan presented by Councilmember Gordon, not a uniform endorsement of the entire thing as it was presented. It's in concept, in theory, the commission supports the ideas and would submit it back to the Policy and Procedures Subcommittee for further refinement, potential public engagement, et cetera, as discussed.
Yes, Mr. Carl, I think that is a much more eloquent way of summarizing my motion. Thank you. Is there a second?
Commissioner Sylvester, I'll second.
Is it possible to have discussion on this? Just so that way we can go over it and make sure that there isn't something, in here that conflicts with what we want. In general, it looks like everything's fine here, but would love to hear a discussion from all of our colleagues on this, if possible.
Would any commissioners like to comment on this matter? Okay, Commissioner McGuire.
I mean, first look at it, it's something I agree with, and what I would just like to know more about, and maybe if you were provided with materials about what other, what has been proposed and excluded from this framework that we have in front of us, and just kind of alternatives, maybe alternative wording or additions or subtractions that have been taken from this model. Just because this is not an area that I'm very familiar with, like, law around traffic stops and what the police might have to stop someone for. I'm just looking at the wording of like a mandatory secondary offense versus a presumptive secondary offense. So I guess there's questions like, are we butting up against the edge of the law of what the police can and cannot do as it exists or not? And I didn't know, are there other materials that went into that talk about the background of that?
So to answer that question, Representative Frazier did go through a rigorous process within the state House in, writing this is a proposed law for the state of Minnesota and, that whole process. And at this moment, I think the motion concerns the framework from Council Member Gordon, which is a separate, we had 2 presentations, so I'm sorry for so much information in a short time, but the second presentation was from Councilmember Gordon about potential changes to civilian oversight within Minneapolis and what that might look like. And he gave us a 2-page document. It's rather short. It's meant to be an overview. It's not meant to be, a deep dive or statutory or anything like that. And what he would like to know basically is, am I going in the right direction? And he would like to continue this discussion over the summer, getting input from community groups, other agencies, so on.
Okay.
I would need more time on just like look into it more. I don't know if you have to vote on it now, but I see Casey's hand up, and then Commissioner Pino.
Madam Chair, and to Commissioner Sarah, perhaps a better way of framing this then, because I hear concern about what is the intention of this vote. And I did attend the subcommittee meeting and was there for Councilmember Gordon's presentation. And perhaps we could revise the motion if you concur. I think the intent that the council member was hoping to get is, does the PCOC support potential changes within the city's code of ordinances that deal with this group's authority in line with his 2-page proposal for changes? Okay. I think rather than saying yes, the motion tonight is we endorse it, because that seems like we've read it, we agree with all the 2 points. Maybe the question is, should it continue to be researched, refined, discussed, potential changes, amendments, perfections brought forward through the Policy and Procedure Subcommittee, so that instead of saying, yes, we love everything, no, we don't, it's really more of, do we want to continue this discussion at a subcommittee level where members and the public can both, engage on this, provide feedback, say, we like this concept and would like to see more of it, or this concept seems to have conflict with state law or other city policies and either would need more research or should be removed. And here are some areas you haven't even considered that we would offer to you. I think really, Commissioner Sarah, that's what I I took away from that meeting, and maybe I didn't phrase that correctly earlier, it's not an up or down, we concur with your proposal. It's a, do we, the PCOC, agree that this direction is important, and we agree to, in collaboration with you, sort of give you our feedback, collect feedback from the public that's following us, and offer that into that process.
Yes, Mr. Carl, that's totally accurate, and I support that. And I'm sorry to make your Roberts rules so messy here, but I would adopt that as my motion, just a vote of confidence in a way, moving forward as a commission, like we think this is the right direction, and we would like to continue to work on it and keep it as an open discussion.
Okay.
Agreed. So do we need a roll call for that?
If there's no further discussion, you can ask for a roll call.
Okay. Clerk, may we please have a roll call, please?
Commissioner Sarah.
Aye.
Commissioner Crockett.
Aye.
Commissioner Jacobson.
I guess what I'm trying to understand, are we voting to table this, or are we voting to move forward on this?
The vote is to keep it at the subcommittee where it's at now for continued conversation. That's all.
Okay. Aye.
Commissioner McGuire.
Aye.
Commissioner Pino.
Aye.
Commissioner Sparks.
Aye.
Commissioner Sylvester.
Aye.
Vice Chair Abdi.
Aye.
There are 8 ayes.
Okay. So I will now direct the clerk to receive and file this report. And I would like to now recognize Commissioner Pino, who will present the audit subcommittee report.
Hi, everybody. I will just briefly give my report so that way you're up to date with what we did in audit committee. We had a few reports from staff, mainly a brief overview from Andrew Hawkins regarding the MPD 911 working group update, and we made sure that that information is at least up on the table for discussion. We might be able to bring it up later once more events and results unfold from that. We also had our first conversation around the coaching referral, which came from this full commission back in 2020. And we decided we wanted to hear the exact presentation we heard tonight before we go any further with it. So we're glad that we tabled that for our next discussion. We also had our first point of new business within this year regarding the no-knock warrants research and study. We asked staff for a feasibility report, which I am happy to say was sent to subcommittee members just before this meeting, which we will be looking at in our next subcommittee meeting. And that was about it. Apart from a report from one of our staff regarding the trans equity study methodology update, which we are still working on making sure that that's getting ready in a proper time. That's about all I have for my report.
Are there any questions from the commission or discussion on this report? Okay. So without any objections, I will direct the clerk to receive and file this report. We will now take up case summaries that are postponed from April meeting under the unfinished business. We will take questions and open the floor to discussion after each case summary is presented. And I would like to recognize Cassidy Gardner to present the first case summary. Is this time, before Cassidy, you speak, is this time for the clerk to discuss? Okay.
Madam Chair, I believe that perhaps Mr. Hawkins was going to address the selection process and any feedback that had come from the community to commissioners about that process. I believe Mr. Hawkins is on the line.
Yeah, absolutely. Thank you, Casey. So for the selection of, was it back in April now? It's again, time's escaping us. The three cases that were identified from the synopses that were issued for that meeting, we have a new staff member doing this. We have a antiquated system that pulls all these cases, and one of the issues that occurred was it's simple as a filter. They hadn't turned it on. So the cases that we pulled, there were a couple cases that were open. Obviously, we're not able to discuss open cases. This was something that we identified. It's actually happened in the past with more seasoned staff. But because we identified it, we wanted to make sure that we didn't delay this process any further. We didn't want to not have case. I mean, obviously we didn't last month, but we didn't want to not do case summaries for that process. So what we did was we actually went back. We compiled the entire list of case synopses from the previous 3 months, all under 2021. And then I believe that was kind of related to the clerk as an option, just saying hey, listen, here's the issue we've identified. These cases can't go forward because we can't do a summary on a case that's not closed. And Mr. Carl, if you want to jump in, it's okay. By all means.
Mr. Hawkins, I was going to just signal to the chair that I was hoping to add once you had completed your comments.
All right. Well, I apologize. To myself for interrupting myself. So anyways, so we sent those out because we wanted to make sure we had something. And there were 3 that were selected. Again, Lisa or the clerk's office can speak to that process. But the 3 that were selected initially that were still open that we can't do, those are just on hold. They're not going away. They're not they're not gone. They're not in a purgatory. They're just kind of in a purgatory, I guess. Actually, that is a fair assessment. We can absolutely present those once they're all closed. We can just add them on to whatever meeting we're doing as kind of just an addendum. So if we'll have the 3 cases you have for that month plus we'll have that case that was identified at a previous meeting that we just weren't able to do. And I say that because again it was a simple mistake. It's happened. It's understandable, but at the same time, we want to make sure that we still have access to those same cases. So hopefully that kind of covered things from our end, and then I defer to Clerk Carl on the rest.
Madam Chair, I know that Commissioner Sarah has asked to be recognized, so I'll be very brief and to the point. I've had conversations with Commission Chair Jackson about the selection process. As you all know, I am new to this. My office and I are both new to this process, as are many of you. It has been my observation that this is a frustrating process to have cases presented in a meeting, trying to come up with a process of selecting those cases and then bringing them forward to the next month. There's not a lot of coherence in terms of which cases are selected or whether those cases are in fact illustrative of policies that are of interest to this body, if there's a thematic through line to those selections. And so Chair Jackson had indicated she also is frustrated, and we've begun the process of having discussions about how we might bring forward to this body making improvements to that process. So I'm sorry she couldn't be here tonight. We did have a fairly lengthy conversation, she and I, to start that process, and have already set the ball rolling to have a conversation to engage the OPCR staff about options that we think could make this a better process, which would align with perhaps policies identified by this body. So if there were spheres of policy in which this body is specifically interested, directing the staff to bring forward case summaries that align with those, that would show right across the longitudinal basis that there is a practice, there is a pattern, there is something here, not just some random pick 3 and they may or may not relate to anything and who knows what they are. And so I don't mean to disparage the process as it has existed in the past, but Mr. Turchik mentioned tonight, if that process doesn't work for this body has within its power the ability to change that. I certainly believe that it needs to be changed. I know I can speak for the OPCR staff. They are open to change as well. We in fact have had several discussions already. I've had conversations with Chair Jackson, all of which is to simply say our goal was simply because it is in the group's bylaws that we have to have the process as it is now to go ahead and continue May, June, and July, and then through June and July, bring forward proposals for change so that there's a smooth, more seamless handoff from what has been, so we continue to fulfill our bylaws requirement, bring forward bylaws proposed changes that align with a new process. I know that sounds overly complex, and I don't mean to belabor the point, but I think we all can occur the process as it exists today does not work and is frustrating for everyone. So I just wanted to share that we do see the need for improvement, and we are working on that. And our hope was to sort of create a menu of options that then the group could pick from, and that would inform the new process that we bring forward, change the bylaws, and hopefully transition to that by summer. So I'll stop talking and just appreciate the ability to put that on the record. Thank you.
Commissioner Sarah.
Commissioner, your microphone's on.
Thank you. Thank you, Mr. Carl. I was actually going to say quite a bit of that, actually, and just say this is kind of a frustrating process. And you made a good point. The way we're doing it right now, we can't do what is in our operating rules, which is to identify patterns or practices, because we don't even know the year that the incident took place, much less, you know, what precinct or what the demographics were. You know, we just simply don't, we don't have enough information to determine a pattern. And since it's in our operating rules and it's not actually required under the ordinance, we can suspend this process. We can vote to suspend it for a period of time. It sounds like perhaps 3 months would be a good period while the clerk's office and the chair work behind the scenes, or for whatever. For context for the other commissioners, we did vote to suspend this process last summer. I can't remember if it was June or July, maybe July, because we just had so much going on as a commission at that time, and we just felt like it wasn't a good use of our time. It takes up a lot of time, and it wasn't really moving the needle in any way. I was going to make a motion, but I see a hand from Commissioner Pino. Yeah.
I wanted to just bring up one final thing in the form of a question to City Attorney. Joel, do you know whether or not the current process that we're going through with picking these is in fact a violation of open meeting laws? It was raised in public comment, so I just wanted to provide an opportunity for you to advise us on that.
Thank you, Commissioner and Madam Chair. I know that there is a lot of talk, and there has been talk about possibly changing the process. Obviously, that's probably a good thing for a number of policy reasons and also process reasons. I think the specific comment had to do with a practice that would involve the commission selecting the cases to hear kind of before the meeting or offline and then hearing those online. I'm not exactly even sure where in the process we are with these missed months or if that's happening now. That being said, the way I view that, and maybe that's an idea that would have some good advantages and could be looked at it during this pause, if there is a pause, or during the next few months. I do think that that's essentially an agenda setting function, and that would not necessarily run afoul of the open meeting law. It's not like I think the open meeting law is designed to cover your formal authorized functions. For instance, if you were selecting your chair and vice chair, or selecting and authorizing a research and study process. But that being said, I mean, those are all valid considerations, you know, in terms of data privacy and also open meeting laws to look at when kind of devising what might you want as a commission to have this process look like going forward. So I don't know where we are in the process, exactly what's before you tonight and how those came about. I can say that I think it's essentially an agenda setting function at this point, and I don't think there are any violations that are going forward, but I do support any discussions to kind of come upon a better process.
Thank you so much.
Okay, any other last comments before we begin?
I make a motion to suspend this process for a period of 3 months, and we can revisit it in 3 months.
Madam Chair, if I could just speak to Commissioner Sarah's motion, I would say I think that's a good timeline for the staff. As I mentioned, I myself have had at least 2 conversations with Chair Jackson. I've had a conversation with Interim Director Jafar. I've had, which also included Mr. Hawkins, Mr. Fussy. And so I do believe that that will give us adequate time to work on options that we would bring forward to the body and give us a chance to what I'll call is realign the operating rules to whatever the final selection is, so that we still are in accord with those operating rules going forward. I know that it's been frustrating, and I apologize on behalf of staff for all the commissioners. Certainly, it's been frustrating for me as well. It's a process that may have worked at a point in time that this body existed, but for the current iteration of the body, it does not. And so I think we all are agreement that we need a process that works and works consistently, advances the goals of this body, allows us to identify those practices and patterns within policy, and that would also be transparent to the public and known in advance, not, as Mr. Fussy had just indicated, done sort of offline in an agenda setting with just the chair and the vice chair, and then brought forward to the group without a clear process. So I think we all are in agreement with sort of that itemized list of what needs to be done. That sounds like a reasonable time frame to get it done. And I appreciate your support. We do have Ms. Gardnier here tonight to make the presentation of the case summaries that are listed on the agenda if you wish to have them. Otherwise, I leave that to your discretion whether we go through that or punt.
This is Commissioner Jacobson. I second Commissioner Sarah's motion.
Chair Abdi, would you like me to call the roll on that, or?
Yes, please. Thank you.
And just before I do, can I clarify, we're talking 3 months, so that would be August to the August 10th meeting?
Yes.
Or
I
to
believe
the
so.
September 14th?
June, July.
August.
I think August makes sense, Lisa, if Commissioner Sarah agrees.
Mm-hmm.
I think August.
All right. Commissioner Sarah.
Aye.
Commissioner Crockett.
Aye.
Commissioner Jacobson.
Aye.
Commissioner McGuire.
Aye.
Commissioner Pino.
Aye.
Commissioner Sparks.
Aye.
Commissioner Sylvester.
Aye.
Vice Chair Abdi.
Aye.
There are 8 ayes.
And are we going to want Ms. Gardner to make the presentation on the case synopses? I'm seeing some head no's. Okay.
I do, Madam Chair, just on behalf of the body, want to offer our thanks to Ms. Gardnier for being with us tonight. She does work in the Civil Rights Department, but not specifically in the OPCR, and had agreed to take on this challenge given some recent changes within staffing with the interim designation of Director Jafar. And so thank you to her for joining us tonight and sitting this long time with us and being prepared just in case. And also, I don't know, Mr. Hawkins, if you were going to make this comment, but before I turn over the chair and hopefully be quiet, I wanted to share with everyone one of the things that Interim Director Jafar did do is to designate Mr. Hawkins, the Chief of Staff in the department, as the principal liaison to this body and to the Minneapolis Commission on Civil Rights. And so it's great to have him in that expanded capacity to provide direct support to the PCOC. So he'll be a regular member of our meetings going forward and working directly with all of the commissioners on their work. So thank you to Mr. Hawkins for taking on that expanded responsibility during this interim period.
Oh, absolutely. I'm happy to do it. Sorry, I was young and a toddler that needs to go to bed. So I'm looking forward to working with all of you. Just, I mean, I know I've worked with this group a lot. It'll expand into MCCR, the Minneapolis Commission on Civil Rights. So yeah, I'm definitely, again, looking forward. I don't think it doesn't feel a lot different to me, but because I've worked in all of you so much, you know, to begin with. But I'm looking forward to whatever the future holds. So.
Okay, so it looks like that might conclude our agenda for this meeting. Commissioner Sarah, I saw something in the chat. Did you have a comment?
I was just wondering if Mr. Hawkins' new role included support of the subcommittees, or if I should now speak to someone else if I need support for myself.
For the administrative support of the subcommittees, I defer to the clerk's office on that. But everything, I mean, all of our communication, I really don't think there's a lot of changes. It's more formalized. But if the clerk's office has any other comment, staffing, like I defer to them. Yeah, so this is still administrative work on the subcommittee.
Okay. Is it time for adjournment? I didn't hate to cut people off. I just, I don't know. Okay. Well, we have concluded all items on our agenda for this meeting. I will see everyone back here for our June 8th regular meeting. Seeing no further business, without objections, I declare this meeting adjourned. And thank you for everyone being patient with me. This is my first meeting chairing the whole thing, so I'm nervous.
You did a
Great
very
job.
good job.
Great job.
Thank you.
Great job.
Thanks for the meeting, everybody.